for invoking the 11th Amendment is where you have a private plaintiff, say Sally Smith, suing the state as such, say the state of Illinois. And if Sally attempts to do that by going into federal court, the 11th Amendment would be a bar. But note, please, that when you're thinking about the 11th Amendment, we're very particular about how we define when it applies. First of all, the suit against the state must be by a private party and not some other government. For example, the federal government or another state government. And it must be the state that's being sued. The state has to be the defendant and not a subdivision of the state either, like a town or a county or something like that. So it has to be a private party suing the state as such in federal court, and then the 11th Amendment is a bar. Moreover, as with lots of doctrines, there are a number of dreaded exceptions to the application of the 11th Amendment. First, recall that I said that the 11th Amendment is a protection for states. They're immune from suit in federal court unless they consent. So one exception arises out of that. The states could consent. They could waive their protection under the 11th Amendment. However, the courts have said that if you're going to argue consent as a way around the 11th Amendment, the consent by the states must be unmistakably clear. The courts are not going to imply it from silence or acquiescence or any other equivocal behavior. But if you have consent, it's unmistakably clear, states can permit themselves, in other words, to be sued in federal court. Another exception, which is a major exception to the 11th Amendment bar on suing states in federal court, is an exception that arose out of a case Ex parte Young, a case that basically drove a Mack truck, or maybe a very large-sized van, through the 11th Amendment protection for states. And in essence it said that you can't sue states, but you can, under certain circumstances, sue state officials. You can sue the Attorney General, you can sue the governor, you can sue the head of the transportation department. If you sue these officials, naming them individually and not the state as such, and you were seeking to enjoin them for their unconstitutional behavior, that suit would not be barred by the 11th Amendment. The theory is that the states cannot authorize their agents to behave in an unconstitutional manner, that would not really be the state acting. It's kind of a fiction. And you can go ahead and get an injunction or a declaratory judgment against the individual state officer to prevent unconstitutional behavior. Now, this exception won't apply if the plaintiff names a state official in his or her individual capacity, but is actually seeking damages to be paid directly out of the state treasury. For example, say a citizen were to sue for the unconstitutional denial of welfare benefits or some other government payment. The 11th Amendment would bar suit in federal court if the plaintiff were seeking to recover those payments, whether or not they named a state official. But if they were seeking an injunction or a declaratory judgment that the behavior of the individually named state official was unconstitutional, that would be permissible and the 11th Amendment would not be a bar. Now, another exception to the 11th Amendment is that private suits in federal court will be permitted if Congress passes legislation under its 13th, 14th, or 15th Amendment authority. Under those amendments, Congress has the power to pass legislation to enforce the provisions of those amendments. And the Supreme Court specifically held in a case called Fitzpatrick v. Bitzer in 1976 that Congress can override state 11th Amendment immunity when it legislates pursuant to its 14th Amendment authority. For example, if Congress permitted a suit against a state as such for damages for gender discrimination, then in that case, even though the 11th Amendment might otherwise be a bar, since Congress specifically and clearly and expressly permitted such a suit, it would not be a bar for that suit. But there are two things to note here. Very important. One, Congress must be quite clear. It has to be perfectly plain that Congress was using its authority under the 14th Amendment to abrogate the state's protection under the 11th. Second, Congress does have the power to override 11th Amendment immunity under the 14th Amendment and presumably the 13th and 15th. But in a very recent case, in the case of Seminole Tribe of Florida versus Florida, decided in the spring of the 1995-96 term, the Supreme Court held that Congress does not have the authority to override the state's 11th Amendment immunity when it passes statutes under the Commerce Clause. Now, at issue in that case was a statute that Congress passed concerning gambling, and it was the Indian Gaming Statute. And under that statute, Congress allowed Indian tribes to sue states in federal court in disputes between the tribes and the states concerning gaming operations and to seek money damages. But in looking at that, the Supreme Court said that Congress could not override the 11th Amendment immunity when it was acting pursuant to its commerce power. And in so doing, the court basically said, look, when the 14th Amendment was passed, 13th and 15th also, these were passed after the 11th Amendment, and so they modify the protections of the 11th Amendment. But Congress's powers under the Commerce Clause and other Article I powers that are in the main body of the Constitution that were granted to Congress, and then afterward the 11th Amendment was engrafted on the Constitution, are limited by the 11th Amendment. The 11th Amendment does limit what Congress can do under those provisions. Now, the case is quite important, not just because it represents yet another instance of the federal government attempting to protect states' interests, but it's also important because it calls into question whether federal courts can entertain suits against states for money damages to enforce environmental laws or bankruptcy laws or copyright and patent laws or a whole variety of business regulations enacted pursuant to Congress's power under Article I or various portions of Article I. So it's an exception to the 11th Amendment, but not as to powers that Congress was granted before the 11th Amendment was adopted. Now, there's one final exception to the 11th Amendment. If the plaintiff began his or her suit against a state as such in state court, as they must, in other words, they didn't go into federal court in the first instance, they did go to the state court, raising a matter of federal law. It's always the case that the Supreme Court may exercise its appellate jurisdiction, even though the suit would have been barred initially if the plaintiff tried to bring it originally in a federal court. This exception, again, assures the uniformity of federal law. So, if you have a private plaintiff suing a state for damages, and that party tries to sue in federal court, the 11th Amendment is a bar. But remember, there are these exceptions, and there are ways around the 11th Amendment. You simply have to sort of make a list of when the 11th Amendment applies and when the exceptions apply. All right, I want to talk about the final limitation on federal court jurisdiction, and it's abstention, the doctrine of abstention. Abstention is judge-made law. It's made up by judges. It's not provided for in the Constitution. And it's been developed for the courts to avoid deciding or abstaining from deciding cases that they could otherwise actually hear, but they decide not to hear them. And pretty much it involves a situation where the federal courts, they have jurisdiction, but there are reasons why they think they'd rather have state courts decide the particular case. Now, there are two kinds of abstention. One is known as Pullman abstention, and it gets its name from a case by that name. Pullman abstention involves a situation where an individual wants to go to federal court and challenge state law, and the individual is raising both state law claims and constitutional claims. But the state law issue in the case raises matters under state law that are undecided or unclear. And depending upon how the state law issues are decided, the federal courts may never have to reach the constitutional question. For example, consider the case of Pullman itself. That case involved a regulation adopted by the Texas Railroad Commission in the 1940s. The regulation required that on trains there be at least one conductor instead of porters. Now, at the time, conductors were typically white and well-paid, whereas porters were typically black and received much lower salaries. The Pullman Company sued, and so did a group of porters, but they had slightly different claims in a suit that was consolidated. The Pullman Company, of course, was worried about paying more money, and their essential claim was that the regulation was not permissible, that it was ultra vires under state law, because the commission didn't have authority to enact it, to issue